All right. All right, here you go. You both solemnly swear or affirm the testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth to help you. Other hand, ma'am. Sorry.
Yes.
Yes.
Other hand, ma'am. Sorry. It's the right hand, ma'am.
Oh, sorry. Yes.
All right. You too, sir? Also, sir?
Yes, sir.
All right. You both put your hands down. Here you go. Ms. Elpin, I'm not sure. I thought you were here I thought I saw your name earlier today when you were here at when the court made its opening information dial. Well, I did my opening information. Under Texas law, guideline child support is guideline child support. If that's what you earned, that's what the legislature says is a fair and equitable amount. If you're going to go ahead and ask the court for deviation, you got to give the court a legal reason. And again, the legal reason it can be that you can't afford it. I'm sorry, that can be a reason, but that will probably not be sufficient to deviate from guideline support. I need to know something that's out of the ordinary or an extraordinary expense that you might have that the average Texan doesn't have. So the bottom line is, ma'am, like I said earlier, the burden of proof falls on you to show why guidelines should not be ordered. And if you cannot meet that burden of proof, the court has no other choice than to order what the legislature says I'm supposed to order. So at this time, I'm going to go ahead and let the state call you both as witnesses, and we'll proceed at that from this point. And the state may go ahead and call your first witness, please. Thank you.
Thank you, Your Honor. I think this time around, Your Honor, I'll call Brenda Elpin first.
Thank you.
What is your full name, Miss Elpin?
Brenda Elizabeth Elpin.
What is the full name of the child in this case?
Aubrey Michelle Elpin.
And when was Aubrey born?
November 11, 2012.
So it wasn't November 19th, 2011?
Yes, 19th. Sorry. I have worked 12-hour shift last night. I've been up right now.
I understand, ma'am. So can you briefly tell the court what is your main, well, actually, do you understand we are talking about the child support review order modification that you didn't sign?
Yes.
So what is
originally we had? I'm sorry.
So I'm about to get there, ma'am. What is your please briefly tell the court what is your main disagreement with that order?
Just that we had originally agreed on something. We came to an agreement that I was going to pay for when I was in school, right before I finished school. There was a surgery. I was going to pay for that. We had came to an agreement, but even prior to that, through our divorce, if I had custody of our child, there was no child support. It was going to be 50-50. Hey, if you need this, it was going to be the same on me, and we both agreed.
Is this agreement? Was this
but now,
was this
obviously it changed,
ma'am?
Now it changed. I'm sorry.
So was this was an oral agreement between y'all? Like
yes, and
talking?
it was through our divorce.
So this was before the divorce decree.
Yes, and it was set on the divorce decree that there wasn't going to be no child support. But
is that your only disagreement with the order here?
No. And now, I mean, after I'm trying to explain, like after 3 years, I guess this is why he's bringing up now this order of child support. So now this is the amount, and during the agreement or what we were trying to come to an agreement to, it was going to be, I believe, $450 or something like that, with me paying the medical, or I don't know. It was something we had agreed, but then he changed his mind right before we finished that session, which was 2 weeks ago, and he was like, nope, never mind, I want the full amount. So I'm like, okay, I can't do the full amount. I'm in the middle of trying to get a consolidation with all my credit cards,
Ma'am,
just because I just
Stop.
got
Ma'am, stop. You're not allowed to go into a narrative, okay? The state has allowed you to ask you questions.
I'm
You
sorry.
answer the
What?
questions. At the end, you can make a closing statement, closing argument if you wish. But for right now, you just need to listen to the question, answer the question, and stop. I get it, ma'am. The original order had a zero child support that was done by agreement, correct, ma'am?
I'm sorry, what?
The original order in your case, custody order, divorce, whatever it was, it had a zero amount of child support order, correct?
Yes.
And that was by agreement.
Yes.
All right. Thank you, ma'am. I'll let the state proceed with the next question, and I'm looking at the date of the order. Okay. Thank you.
Thank you, Your Honor. What is your current employment?
Mine?
Mm-hmm. What do you do?
I'm a nurse.
And how much do you make as a nurse?
$27.80.
And how many hours per week do you work?
37, 38.
And
I work 3-hour shifts.
what state do you live in, ma'am?
New Mexico.
And Your Honor, I should note that we included New Mexico's income tax as a credit to her. That's the witness.
All right, ma'am. I know you're not a lawyer, and here's what it is, ma'am. Under Texas law, your agreement, it was your agreement. But after a period, and I'll relook this up to confirm, but because I hadn't looked at it in a couple of years, I don't think the legislature has changed it. But after 3 years, up to 3 years, that's carved in stone. That was, zero child support was the amount that was agreed to. So that's the way it is. However, upon modification of that child support after 3 years, the state and the father, the father has the absolute right to ask for a child support modification, and in order that it be set at the guideline amount. And right now, based on what you earn, including and taking out income tax and the things that Social Security, Medicare, Medicare, and your income tax from the state of New Mexico, this is what the state is telling me is the guideline amount that the law requires me to order. And for me to do something differently at this point, you got to give me a legal reason to do so, ma'am. Again, like I said earlier, it definitely can't be that you can't afford it. I need some other data. So something that's special, that's out of the ordinary for anybody else. Because the bottom line is, Mr. Albert has the right to ask for that, and I have the obligation to order it. So at this time, you need to tell the court why the court should not follow what the Texas law says I'm supposed to do at this point, based on the fact that the Texas was where you got your divorce, and Mr. Elpin and the child still reside here. So at this time, ma'am, what else can you tell me?
I mean, I don't know what else you want me to say other than obviously that's a big amount. I'm in the middle of consolidating all my credit cards, everything that I have to do. And I don't have that amount until January, just because like I told Seth, hey, I just finished school, less than 6 months ago. So my whole financial, it's like I'm stabilizing everything. So it's never been a reason of I'm not going to pay, or I don't want to, or I'm fighting it. I'm not doing that. It's just let me get my financials together and I will.
All right, ma'am. Are you saying
that was it?
Are you saying that obviously this order starts before January 1st of next year? Are you saying that based on your circumstances that it'll be best if I had to order it, you would want to order the first day of January instead of the current order is now ordering it, ma'am? Or are you requesting a different amount?
It's already ordered January 1st, Your Honor.
Already is set for January 1st. Okay.
Mhm.
Yeah, see,
All right.
I didn't know that. I mean, I think it was more, I don't know. I just, it's
Yeah, I know.
a big
Like I
amount. I
said,
mean, it is a big amount. I don't know how much I'm going to have to pay for my consolidation. As of right now, the estimate is about 1,000 a month. So I'm trying to get my finances together just so I can be okay and live okay and still help with her. And I'm not saying I'm not going to send like, hey, if it's medical, like I told him, like I'll
okay,
pay.
ma'am, again, you go into a narrative here.
Okay, I know.
And
Okay.
ma'am, here's the deal. Like I said in my morning speech, I get it, 20%. If I had to pay
understand.
20% of my money this month going out next month to child support, yeah, judge might have to trade cars. You know, that's how much the money that is. 20% is. But the bottom line is, ma'am, that's what the law requires me to look at. And I'm going to let the father testify to what he wants here in just a moment. But again, ma'am, I understand you want to try to get your ducks in a row, but yeah, it's been more than 3 years, so it's time. The court has the obligation to go ahead and set this up. So I'll go ahead and let the state finish with any questions they have of you, and then call the next witness. Thank you. Any other questions of Ms. Elvin at this point, Mr. Welch?
No, Your Honor. Pass
All
the
right,
witness.
I'm going to be back I'll be back with you in just a moment, ma'am, while you give some thought to see if there's anything else you want to tell the court about the circumstances that would warrant me doing something different. So at this time, the state may call your next witness. Thank you.
State calls Seth Elpin. What is your full name?
Seth Thomas Elpin.
All right. So what has changed since y'all's divorce decree back in 2021 when it comes to cost of the child?
She's a teenager now. There's a lot more costs associated with an older child. Clothing costs more. Then also she does martial arts, which has a yearly cost. She's on the school basketball team. She had medical procedures, hip surgery recently that I had to pay for. Cell phone that she has now, different things. The cost of food has gone up significantly. Just the cost of living in general. So I'm trying to ensure that she can continue having what we've been able to provide for her, and to cover her extracurriculars, to cover her medical costs, as I'm the only one that pays for it. There's no vision insurance, and she wears contacts. That's a new establishment. There's no dental insurance. There's other things like that that I pay completely out of pocket without any assistance, despite previous requests for it.
And so just to make sure, this order that you signed, you've read it and you're okay. You agree to the terms that is in it.
Yes, sir.
You have anything else you'd like to tell the court?
No, sir. I tried to go through the negotiations and
You have to explain negotiations, and that's something the court under law doesn't consider what y'all said and did during negotiations. So again, it's what you're asking the court to do here today, as far as your testimony is concerned, what counts, and that's what the state needs. Is there anything else you think, as far as your testimony is concerned, what you're requesting, sir? Thank you.
Understood, sir. No, I have nothing else, sir.
All right, Mr. Welch, any other witnesses?
No, Your Honor.
All right, Ms. Elkin, I'll let you have one last opportunity to tell the court why the court should not order a guideline at this point, based on the fact I give you a couple of minutes to think about it. Is there anything else, ma'am, you think I need to know?
No.
All right, Mr. Elkin, anything else, sir?
Negative, sir.
All right, folks, here's the deal, Ms. Elkin, and my apologies, but again, the law is pretty much the law. The legislature says 20%. The state has done the math and come out with what 20% of your net income is. Again, like I say, 1/5 of your income going out every month toward child support. Yeah, I understand, ma'am. But the bottom line is, the legislature said that's a fair and equitable amount. 95% of everybody that walked in the courtroom today who made what you made today in the state of Texas walked out with this exact same child support amount as being the correct amount based on what the law requires me to do. And ma'am, you have this is the only child you have at this time, the only child either living with you or has that you're legally obligated to support. Is that correct, ma'am?
Yes.
All right, then, ma'am. The court is granting guideline child support based on the math of the circumstances. I'll ask the state to present the child support review order with the attachment showing this is what the court has ordered based on the testimony and circumstances. Again, ma'am, you have the absolute right not to sign this. You have the absolute right to appeal or de novo this. You can do whatever you feel like is in your best interest, ma'am. But again, the court at this time is following what the law requires. And it's up to you. If you want to try to request something different, you can. But based on what I have here today, folks, this is what the law is going to require me to do, and it's so ordered. Is there anything specifically the state needs me to rule upon at this point, sir?
Basically, Your Honor, so essentially you're confirming the order as is.
Yes, sir.
That's it, Your Honor.
And that includes with the child visitations, right? Because I haven't seen my child in over a
Hey,
year.
stop. Here's the ma'am. This order only
Just
pertains.
saying, just asking.
Okay, this order only pertains to the modification of child support. Your original divorce decree is what is what your visitation order is about. All right. Y'all didn't change anything in visitation in this order, did you, Mr. Welch?
No, Your Honor. This is just child support, the health insurance, which is through Mr. Elpin, no dental. Yeah, that's about it.
All right, so ma'am, whatever your order is for your visitation, that's the order that still is control. While the state now can't give you any legal advice on that, you may want to talk to your own lawyer about what your rights are under that. But obviously, that's the order that is in effect right now. This order only modifies the child support aspect of your prior decree of divorce. Any other questions, ma'am?
No.
All right, Mr. Elfin, anything else, sir?
No, sir.
All right, Mr. Welch, I will waive court costs in this matter for either party, and I'll ask the state to prepare the order and circulate it for review, and then forward it to the court. So, when the parties may excuse Mr. Welch, or you want to back and break out to look at the prepared order?
Back and break out, Your Honor. The only thing I'll need to change is that we did court costs as billed on or before November 17th, 2026. So I'll have to just change that to waived. But that's it. Yeah, just it won't take long, Your Honor.
All right, then, Mr. Mr. Elpin, the state will get you back in breakout. You'll get an opportunity to see what the final order looks like. Again, you don't have to sign it unless you want to, but the state was going to present it to the court to sign off on it. So long as it is what I rendered here today, the court will sign it. And ma'am, like I say, the clock is ticking. If you wish to do any type of appeal or de novo, you need to do those in accordance with the Texas Rules of Civil Procedure. Again, I just start speaking like a lawyer, but that's what happens in the court of law. So at this time, the state's going to put you back in breakout, and we're off the record. Thank you.
Thank you, Your Honor. All right. Miss Elpin, Mr. Elpin, moving y'all now. Mr. Elpin, you're going to go to room 46. Miss Elpin, you're going to room 47.
Share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.